The Americans with Disabilities Act, as well as the Americans with Disabilities Act Amendment Act, deal with the employee that may have a disability and the obligations of the employer to provide reasonable accommodations. Now, the Americans with Disabilities Act Amendment Act was signed in 2008 because historically the definition of disability was so restrictive that a number of individuals were being denied disability because the definition was very limited. So the definition of a disability is a mental or physical impairment that substantially limits one or more of the major life activities of an individual, or having a record of such an impairment, or being regarded as having such an impairment. That satisfies having a disability. But what was happening was that a doctor would say the individual has a disability, and when they would apply for disability coverage, they were being denied because it didn't satisfy the restrictive definition of a disability. Please note that disability does not include homosexuality, sexual behavior disorders, gambling, current drug abuse. So if you are a current drug user, that does not satisfy the definition of disability. However, if you were a former drug user now in rehab and perhaps you have some side effects from prolonged drug abuse, that may satisfy a disability. Now, notice in the definition it says that this impairment has to limit one of your major life activities. Major life activities include walking, seeing, hearing, pretty much the individual activities that you perform in your daily life. Not just your tasks that are specific to your job, but they include major life activities that are specific to performing daily life tasks. Now, an employer under the ADA as well as the ADAAA cannot discriminate. They are prohibited from discriminating under the ADA, whether that is denying equal jobs or not providing the accommodations. Okay, so a reasonable accommodation can include measures such as making the existing facilities readily accessible. So if I am in a wheelchair, then you have to provide hallways that are wide enough for the wheelchair to have access. You can't just decide that you are not going to hire an individual because they are in a wheelchair. Now, employers, once they are notified of the disability, they are required to make reasonable accommodations. Again, reasonable accommodations are things that would allow an individual to perhaps modify their work schedule, reassign the employee to a different position, something that would fit into their schedule. So if I have a condition where I can't see at night, perhaps you work with me so that I come in early and I can get off in the daytime so that I don't have to drive at nighttime. It really just depends on what disability the individual has. Okay? The onus is on the employee to suggest workable and affordable changes that the employer can make. So the employee has the burden to bring this to the employer's attention. You may be required to provide documentation, and once that is done, then the burden shifts to the employer to make reasonable accommodations. Now, there are some defenses. So an employer can say, well, we have the requested accommodation poses an undue hardship on the employer. This is a defense, but it is very important that the employer have to document that. And financial difficulty alone is not usually sufficient, because there have been times where an individual employer has said, okay, well, we can't do that. There have been cases in Maryland. There are some restaurants in downtown Baltimore City that have 2 stories. And they said, well, you know, the individual who comes that may be a patron of the restaurant is in a wheelchair, or we don't have a lift so that person can eat on the 1st floor. So that's their accommodation. Well, the Maryland Human Relations Commission said, no, that's not going to work, because if that individual wants to dine on the 2nd floor, then they should be given the opportunity. You are denying them. So if you have an employee who's in the wheelchair, they cannot go to the 2nd floor and wait tables there. I mean, so there are so many different things that the employer has to take into consideration. And if that employer then comes back to say, well, we can't make that accommodation because it's going to cost us money, the financial difficulty alone is not usually sufficient. You have to really demonstrate that there is a hardship. An example of a hardship would be we are in a historical building. We cannot make modifications to it. Well, then that is a hardship. Okay, some other defenses that the employer can raise was, okay, the employee brought this disability to our attention, accommodations were offered, but the employee refused. So then if the employee refused, then if something happens later on, the employee cannot come back and say, well, the employer didn't offer accommodations. Well, yes, I did. You just refused them. Okay? Like I said, the other defense could be that it's an undue hardship, but keep in mind that it has to be more than financial. It has to be some extenuating circumstances. Okay, so it's significant difficulty or expense, considering factors such as the nature and cost of the accommodations. It cannot just be finances alone. Okay, or that the employer was unaware of the need of the accommodation. Again, it is on the employee to bring the disability to the employer's attention. Okay, or another issue that the employer would raise, depending on what the disability is that the individual poses a threat to the health and safety of others. Now, there is something called a perceived disability, and perceived disability goes back up to being regarded as having such an impairment. So, obesity. Is obesity a disability? Whether it be standard obesity or morbid obesity, obesity by definition has not been considered a disability. It is the things that stem from obesity, like high blood pressure, perhaps the inability to walk, that manifest into the disability, but just being obese by itself is not a disability. However, there's been case law that there was an employer at an auto parts warehouse that this individual worked for, and he was obese, okay? And he was a delivery stock worker, which meant that he had to drive to deliver these auto parts. So the company had 3 delivery vehicles. One was a Ford Fiesta, a Geo Metro, and a Suburban truck. Again, keep in mind, this is a fairly old case, so some of these cars may not even be in existence, like a Geo Metro, but to just give you an idea, it's a really small, compact car. And this particular employee, because they kept saying he was so fat, he was so big, they would not allow him to use the Ford Fiesta or the Geo Metro. They told him he always had to get in the Suburban car. His coworkers harassed him, and the store manager and the owner told him to get used to it because he was big. So at that particular time, he then says, hey, well, because I'm big, I need some accommodations. I can't do. The employer then asked him to do something else, and because he said, well, I can't do that, can you make some accommodations? They said no, and then they fired him. So he sues, and he sues under the ADA and this disability discrimination. And his employer said, well, obesity is not a disability. Well, the court then says, well, there is a such thing called a perceived disability. And there are 3 ways in which an individual without a disabling impairment may be regarded as being disabled under the ADA. That is, the employee may have an impairment which is not substantially limited, but perceived by others as substantially limiting. And then that impairment which is substantial because of the attitudes of the others towards the impairment. Or they have no impairment, but the employer regarded them as having a substantially limiting impairment. Okay? And because of this, the court said you treated this individual, although obesity is not considered a disability and not an impairment, you treated him as though it was, so therefore you perceived his disability, and therefore you have to give him reasonable accommodations. They limited his duties because he was perceived as being disabled. They wouldn't allow him to drive certain vehicles. So therefore, you have been acting all along as if he was impaired because you didn't give him the same responsibilities as others. So now, because he's asking for something because of this, what he perceives to be an impairment, you can't then switch the clock back and say, wait a minute, you don't have a disability. So if you have someone, an employee, then you need to treat them as you treat everyone else, because the minute that you attempt to exclude them or treat them differently, then if they come back and say, well, based on what you perceive to be my disability, now it is interfering with a life activity and I need some accommodations, you can't then say, oh, well, that's not a disability, when all along you've been treating the individual as if they had a disability.